You wouldn't think visiting your own parents could spark a legal battle, but in our case, it did. And not because of anything my folks did. No, it was thanks to a woman with a clipboard, a title no one actually gave her, and an ego large enough to blot out the sun. What started as a simple trip to help my dad with a leaky faucet would eventually lead to the entire Homeowners Association being stripped of its authority and banned from operating in our county. It began when my parents, both in their early 60s and ready to downsize, bought a charming little ranch home in a subdivision called Creek-Eyed Meadows. The place had all the usual suburban touches: fresh paint, identical mailboxes, and perfectly trimmed lawns. It wasn't advertised as a 55-plus community. Not in the listing. Not by the realtor. Not in a single document my mom read over, twice. To them, it was simply the perfect spot for quiet living and light gardening. Even better, it was closer to me, which meant more coffee visits and impromptu dinners. Everything was idyllic at first. My parents met a few kind neighbors, settled in nicely, and started enjoying their new home. I dropped by occasionally to help out. One visit, I mounted a few pictures, another time I got their new smart TV set up. Nothing out of the ordinary. No alarms. No signs of war brewing on the HOA front. That changed with the arrival of a thick manila envelope. Inside, a binder's worth of Creek-Eyed Meadows HOA rules and a letter from the president herself, Agnes Periwinkle. The letter, dripping with condescension, set the tone. Among the gems, needing approval to change your welcome mat and strict guidelines on lawn gnome placement. We laughed it off, figuring this was standard HOA fluff that no one really enforced. But that changed one Saturday morning. I'd pulled into my parents' driveway, toolbox in hand, ready to tackle the aforementioned faucet, when a woman from across the street appeared. Stiff posture, critical eyes, a permanent scowl, Agnes Periwinkle in the flesh. She didn't greet me so much as interrogate me, clipboard clutched like a weapon. My dad came out, explained I was his son, just visiting to help out. Agnes didn't flinch. He doesn't live here, she stated. Then she cited Article 7, Section B, Subsection 4, proclaiming Creek-Eyed Meadows as a 55-plus community where visitors under 55 were closely monitored for frequency and duration. She wasn't finished. Contractor vehicles, she informed me while glaring at my car, were not permitted in driveways. I wasn't a contractor, I was family, but that didn't seem to matter. Dad thanked her curtly and assured her I'd be gone that afternoon. As she turned and strutted away, the chill she left behind lingered. Once inside, we were all rattled. Mom was shocked, no one had told them they'd moved into an age-restricted community. The realtor hadn't said a word, and there was nothing in the sale documents. Dad, ever the judge even in retirement, promised to comb through every page of paperwork to find out what the truth really was. That night, as I drove home, I couldn't shake the feeling that this wasn't just an annoying misunderstanding. This was the first shot fired in a war over something far bigger than a faucet. And sure enough, in the days that followed, my dad, papers strewn across the dining table, highlighter in hand, found something that made his voice harden with purpose when I called. "It's ambiguous," he said. But even in that word, I could hear it, the first crack in the HOA's armor. The document said nothing definitive about age restrictions. The purchase agreement itself was boilerplate. But deep within the HOA's CC and RS, on page 47, buried in fine print, there was a vague clause that mentioned Creek-Eyed Meadows' aspiration to eventually qualify under the Housing for Older Persons Act, HOPA. It encouraged residents to be 55 or older. Encouraged. It didn't declare the community as currently compliant with HOPA, nor did it mention visitation restrictions even remotely resembling the kind Agnes had cited. That distinction was massive. HOPA provides exemptions from fair housing laws around familial status, but only if strict conditions are met. For example, 80% of units must house someone 55 or older, and the HOA must have written policies proving their intent to maintain that standard. Aspiration and encouragement were far cries from a binding, enforceable designation that allowed someone to bar family members from visiting. It was clear Agnes was overstating her authority, but challenging her would require using the HOA's grievance system, which, unsurprisingly, was most likely overseen by Agnes herself. A bureaucratic booby trap. That Sunday, I visited again, not out of defiance, but because my mother invited me for lunch. I made a show of parking on the street, hoping to keep the peace. I hadn't been inside 20 minutes, just sipping coffee and chatting, when there was a sharp knock on the door. It was Agnes. This time, she brought backup, a thin, nervous man with a notepad and pen, her scribe or witness, no doubt. Her face was stonier than before. In her hand, she clutched a formal letter. "Mr. and Mrs. Henderson," she began, her tone inflated with imagined authority. "I issued a verbal warning last week regarding visitation." My dad stepped forward, his voice calm but firm. "Agnes, my son is here for lunch. He is not living here. What is the issue?" She handed him the letter like it was radioactive. "The issue, Mr. Henderson, is that Creek-Eyed Meadows is a community for residents aged 55 or older. Your son," she glanced at me, her tone full of disapproval, "is not 55. His repeated presence constitutes a violation of our established rules and the community's character. This is a formal written warning. A copy will be placed in your permanent file." My mother gasped. "A permanent file? For our son?" Agnes ignored her. "Furthermore," she said, voice rising, "unless your son can provide verifiable proof of being 55 or older, or receives a time-limited compassionate exemption, which requires documentation, he is no longer permitted on Creek-Eyed Meadows property. Any future unauthorized visits will be treated as trespassing. Law enforcement will be contacted." This was no longer annoying. It was outrageous. "A ban? Because of my age? You can't be serious," I snapped. "This is their home. I'm their son." Agnes's eyes narrowed. "These are private roads, maintained by the HOA. The covenants give us enforcement authority. It's all in the documents, if you had read them thoroughly." Her gaze flicked to my father, clearly daring him to challenge her. He took the letter silently. Then, in a tone sharp enough to slice stone, he said, "Agnes, you are treading on very thin ice. I suggest you and your associate return to your duties. We will review this communication." The man beside her paled visibly. Agnes, however, seemed to swell with self-importance. "See that you do," she sniffed, before turning and marching off, her note-taker scuttling behind. We stood in stunned silence. The smell of roast chicken from the kitchen now seemed to mock us. Lunch was ruined. My parents, homeowners, were being told who they could see, based on a gross distortion of a vaguely worded clause. It had turned personal. Agnes Periwinkle had made a grave mistake. She had no idea who she was dealing with. Not just me, but my father. A retired judge with more courtroom battles behind him than she could imagine. The official warning was a masterclass in overreach, citing articles and subsections like gospel truth, threatening fines, property liens, and police involvement. My mother was visibly shaken. "She can't do this, Robert," she said, voice trembling. "Ban Michael from our home?" Dad's jaw clenched. "She thinks she can, Eleanor. That's the problem. This letter is full of assumptions. It's written to scare people into compliance." He turned to me. "Michael, let's not provoke her just yet. Don't visit for now. The last thing we need is a fabricated trespassing charge making things worse." I hated it, but I agreed. I couldn't risk my parents being fined or harassed because of me. But the idea of Agnes controlling our family like this? Unbearable. So, the fight began. My father dusted off his legal books, tapped into old networks, and began formulating a response. I became a digital detective, diving into county records, zoning archives, and planning commission portals, searching for anything, that could verify Creek-Eyed Meadows as a true HOPA-designated community. What I found was revealing. Or rather, what I didn't find. No official HOPA designation. No county approval. Nothing in any state registry. Just generic subdivision permits and standard development plans. That aspiration buried on page 47. Legally meaningless. Meanwhile, Dad reviewed the HOA's incorporation documents. Interesting, he said one night, a spark in his voice. Creek-Eyed Meadows HOA is just a non-profit managing common areas. It mentions nothing about enforcing age restrictions. For them to legally restrict visitors based on age, they'd have to comply with HOPA's 80-20 rule and perform age verification surveys, something my parents had never seen or signed. Dad explained further, HOPA compliance isn't just a title you claim, it's a rigorous legal structure. Without documentation, without consistency, without transparency, Agnes's threats were empty. Worse, they could be illegal. Agnes isn't just overreaching, Michael, he said, she's crossing into outright discrimination. Battlefield. That single sentence from my father landed with the weight of a gavel striking hardwood. It was no longer a matter of negotiation or polite correction. Agnes Periwinkle had rejected the opportunity to resolve this amicably. Instead, she had doubled down, clinging to her imagined authority like a monarch facing rebellion. But what she failed to grasp, or perhaps simply refused to acknowledge, was that her kingdom was built on sand, and the tide was coming in fast. Over the next several days, our response took form. Ms. Albright began drafting a formal complaint to the county commission, complete with exhibits, the lack of HOPA compliance, the HOA's articles of incorporation, and my parents' signed affidavit detailing the misleading welcome materials and retaliatory treatment. We included excerpts from the Fair Housing Act and case law showing that a stated aspiration to qualify under HOPA did not confer the legal right to discriminate based on age or family status. Meanwhile, I continued reaching out discreetly to other residents, using the cover of casual walks and friendly conversation to gauge their appetite for change. To my surprise, there was more quiet support than I'd anticipated. A retired librarian offered to anonymously confirm the absence of age surveys in her 20 years of residence. A widower down the street confessed that he'd been afraid to host his visiting grandchildren for fear of drawing the ire of the clipboard queen, as he put it. Even the couple in their 40s who had previously stayed silent hinted that they might be willing to sign a petition, provided it didn't make them public targets. Slowly but steadily, the case against Agnes and her cronies grew stronger, not just legally, but communally. What had begun as a personal vendetta was transforming into a grassroots reckoning. The residents of Creekside Meadows, long cowed by bureaucracy and fear, were beginning to stir. Dad's strategy now had a secondary component. We would not only file the complaint with the county and possibly the state attorney general's office, but also begin laying groundwork for a recall of the HOA board under the association's own bylaws. This required signatures from a certain percentage of homeowners, a high bar, but not an impossible one if the momentum continued. And it was. The phrase, the 55-plus farce, began circulating quietly in conversations and group emails. Someone created a private online forum for residents to discuss HOA concerns away from Agnes's scrutiny. Questions about financial transparency and board elections cropped up more frequently. What Agnes had dismissed as one family's disruption was turning into a movement. Ms. Albright prepared the next salvo, a formal demand for the HOA to provide documentation of its HOPA compliance, past and present, including resident age surveys, published policies, notices to buyers, and proof of the 80% occupancy requirement. She gave them 10 business days to respond. Meanwhile, Dad reached out to a local housing rights nonprofit with experience in discriminatory HOA enforcement. They expressed interest in supporting the case, particularly given the broader implications for other communities that might be using HOPA as a smokescreen for exclusionary practices. This isn't just about your son visiting for lunch, one of their legal analysts said. It's about whether an HOA can wield imaginary authority to trample the Fair Housing Act and expect no one to challenge them. Those words gave me chills, not of fear, but purpose. Agnes Periwinkle had tried to gatekeep a neighborhood, to weaponize policy against common sense and decency. But her tactics were unraveling. And so was her illusion of control. Path now we choose ours. Agnes Periwinkle had called our bluff, or what she assumed was a bluff. She didn't realize she wasn't just brushing off a disgruntled resident but was instead challenging someone with an expert grasp of the legal boundaries she was recklessly trampling. Her arrogant dismissal served as the catalyst we needed for the next and far more serious phase of action. The gloves were off. Agnes had doubled down on her flimsy, self-appointed authority, and in doing so handed us the perfect justification to escalate this to a level far beyond what she could anticipate. She thought she was defending her quaint little kingdom, but in truth she was sealing its downfall. Our next move was the county complaint. The formal filing to the county commission was a carefully constructed document. Miss Albright, with Dad's detailed guidance on procedural and municipal matters, authored a petition that wasn't about my ban anymore, though that had sparked it, but instead focused on deeper systemic failures in Creekside Meadows. It outlined 1. The HOA's ongoing misrepresentation of Creekside Meadows as a HOPA-compliant 55-plus community despite the lack of any formal certification or registration with the county or state. 2. The failure to comply with HOPA's operational standards such as documented age verification surveys or proper disclosure protocols to incoming homeowners. 3. The unlawful enforcement of rules like my visitor ban stemming from a status they had no legal right to claim, potentially violating the Fair Housing Act. 4. A climate of coercion and secrecy fostered by the HOA board, especially its president Agnes Periwinkle, who had created a culture of fear to discourage dissent. And 5. Suspected financial mismanagement. If HOA dues or fines were being used to maintain this illegal enforcement regime or penalize residents unjustly. While this last point was speculative, it warranted a closer look. The petition requested a formal inquiry into Creekside Meadows' HOA's legal legitimacy, its adherence to relevant local and state statutes governing homeowners associations, and its compliance with federal fair housing laws. We also requested a temporary injunction to halt the enforcement of any age-based restrictions until the matter could be resolved. Importantly, the petition made clear that if the HOA was shown to be fundamentally misrepresenting its nature or exceeding its legal mandate in a way that harmed residents or contravened public policy, the county could pursue corrective actions up to and including the revocation of its operational permissions or petitioning a court to dissolve its leadership and appoint a neutral administrator. This was the ban from the county concept reframed in the precise language of public accountability. It wasn't about vengeance, it was about dismantling an illegitimate system. We included a full evidentiary appendix, the property listings, the CC and RS with their ambiguous aspiration clause, the county search confirming no HOPA registration, the threatening letters from Agnes, her defiant reply to Miss Albright, and a signed affidavit from my father outlining the misleading information presented during the home purchase. Miss Albright also secured an anonymized statement from another resident who'd been age-targeted by the board, adding more weight to the narrative. The petition was submitted to the county clerk and certified copies went to Agnes and her board. Again, this time we expected their reaction would be less arrogant and more alarmed, or at least that was the hope. Surprisingly, the normally sleepy county commission, accustomed to zoning permits and local bond issues, took the matter seriously, and HOA flagrantly disregarding fair housing law and possibly misleading its residents wasn't a routine case, and the professionalism of our filing likely helped. They scheduled a preliminary hearing summoning Agnes and the Creekside board to appear. Suddenly this wasn't a personal spat, it was an official investigation by the county government. Dad remained calm and resolved. Mom was nervous but hopeful. I was tightly wound with anticipation and conviction. We knew Agnes would fight. Her sense of self was completely tied to her role as the iron-fisted steward of Creekside Meadows. We anticipated deflection, righteous indignation, maybe even an attempt to cast herself as the wronged party, a public servant harassed by legal saboteurs. Miss Albright prepared us. Let her talk, she said. The more she digs, the deeper the hole. The day of the hearing arrived. The county commission chamber was unimpressive, a wood-paneled room that smelled faintly of disinfectant and old carpet. A handful of Creekside residents had shown up. Clearly the word had spread. Agnes entered with Mr. Peterson trailing behind her, visibly nervous. She wore what was likely her best formal attire, a stark navy suit, and clutched a stuffed briefcase surely brimming with whatever counter-arguments she could muster. Notably, she arrived Without legal counsel, a serious misstep, but characteristic she likely believed her sheer will and self-assurance would suffice. Commissioner Davies, the chair, a dry, methodical man, opened the session. Miss Albright calmly laid out our case, detailing each point from the petition and reinforcing the legal void beneath the HOA's 55+ enforcement policies. She highlighted the harm to residents both materially and emotionally and the legal risks the board was incurring. Then Agnes took the floor. She adjusted her collar and launched into a rambling defense, painting herself as a devoted volunteer upholding community peace. She insisted the 55+ aspiration was well known and implied my family were agitators trying to undermine a tranquil neighborhood. She waved her copy of the CC and RS like scripture. Commissioner Davies asked plainly, had the HOA ever formally applied for or received HOPA certification? Agnes hesitated briefly, then said it was their documented intent that they were acting in line with that intent, but no, she didn't have certification. When pressed again, she doubled down, saying they operated as a 55+ community because that's what residents wanted. Commissioner Evans then interjected, asking if she understood that enforcing age-based rules without legal status could constitute a fair housing violation. Agnes scoffed, saying it was just community standards and that everyone had agreed when they bought in. She then made a catastrophic misstep, locking eyes with my father in the gallery, and said with open disdain that some people like Mr. Henderson should know better than to think they're above the rules. The entire room seemed to inhale sharply. Insulting a respected retired judge in a public legal hearing was wildly inappropriate. Commissioner Davies fixed her with a hard stare. Miss Periwinkle, he said quietly, Mr. Henderson's past profession is not under review. Your HOA's legal foundation is, and so far your answers have been vague and troubling. He turned to Mr. Peterson, the secretary, and asked if he was aware of any HOPA certification. Peterson stammered and admitted he wasn't, but that Agnes had always handled those things. Agnes shot him a glare that could melt steel, but the damage was done. The commission had heard enough. Commissioner Davies announced they were forwarding the case to the county attorney for a full legal review and issued a preliminary directive that Creekside Meadows HOA must immediately halt all age-based restrictions on residency or visitation. Pending the county's final determination. The room went still. The silence was thunderous. Agnes looked like she'd been slapped. Mr. Peterson looked ready to faint. For the first time in years, the invincible wall of intimidation around Creekside Meadows had cracked and sunlight was finally leaking through the facade. After completing their review, the commission issued a final ruling, effectively lifting my ban, at least for the time being. Agnes Periwinkle looked thunderstruck, her usual stern, controlled expression twisted with shock and anger. She had arrived confident she'd crush a minor annoyance and reassert her dominance, but instead, her entire operation was now officially under scrutiny, and her primary instrument of control was forcibly taken away. She tried to voice objections, but Commissioner Davies silenced her with a firm strike of his gavel. This hearing is adjourned. The tension in the room was palpable. Agnes Periwinkle had just encountered a force far beyond her usual reach, the power of due process and legitimate law, and this marked only the beginning of her downfall. The county attorney's investigation had been both thorough and swift. Starting with our carefully assembled dossier, Ms. Albright supplied any additional information requested. They subpoenaed the HOA's financial records, meeting minutes for the last 5 years, and all communications regarding the 55+ policy. What emerged was far worse than we'd feared, moving beyond simple misrepresentation into potential gross negligence and fiduciary breaches. Agnes Periwinkle and her compliant board had not merely claimed the 55+ status, they actively promoted it as a done deal in informal talks with some realtors, though thankfully not my parents' realtor, to lure older buyers, despite never completing the legal steps to formalize it, nor maintaining the required records or conducting mandated surveys. This selective deception was a serious violation. Moreover, forensic accountants exposed questionable spending. HOA funds were diverted to serve Agnes's personal vendettas, including widespread mailings of warning letters about trivial infractions disproportionately targeting anyone who had challenged her authority. Large payments went to a landscaping consultant who was Agnes's nephew, for overpriced or sometimes unperformed services. Meeting minutes had been heavily scrubbed to omit dissenting voices or tough questions. The HOA secretary, Mr. Peterson, confessed under questioning that Agnes dictated everything, while board members were either too scared or indifferent to resist. He admitted being pressured to find violations against residents she disliked. The county attorney's report, delivered to the county commission 2 months later, was damning. My father, M. Albright, and I attended the public session where the findings were revealed. Agnes Periwinkle was present too, markedly less confident and accompanied by a stern-looking attorney who clearly grasped the severity of the situation better than she did. The report concluded that Creekside Meadows HOA, under Agnes's leadership, had systematically misrepresented its status as a compliant 55-plus community with no legal basis, unlawfully enforced discriminatory rules likely violating the Fair Housing Act, engaged in financial mismanagement and lacked transparency and proper governance, and breached fiduciary duties by failing to protect members' interests and exposing the HOA to significant legal and financial risk. The county attorney recommended several measures: immediate and permanent cessation of all 55-plus claims and enforcement until the HOA could properly meet legal requirements, which, given their record, seemed doubtful, mandated new HOA board elections overseen by an independent party appointed by the county to ensure fairness and remove the entrenched leadership, and most dramatically, the county attorney suggested the commission petition the state to place Creekside Meadows HOA into temporary receivership to untangle finances, reform governance, and ensure legal compliance. If reform failed, dissolution was floated as a last resort. While this didn't ban the HOA outright, it stripped Agnes and her regime of power, effectively resetting the HOA under state and county supervision. For Agnes, it was a public humiliation and complete destruction of her authority. The commission unanimously accepted the report and moved forward with all recommendations. Agnes's lawyer pleaded for leniency and a chance to correct misunderstandings, but the evidence was overwhelming. Agnes sat silently, pale, as the order for supervised new elections was issued, ousting her and her cronies, and the process to appoint a temporary receiver began. My ban became irrelevant, overridden by the collapse of the very authority that had imposed it. I was free to visit my parents anytime, park in their driveway, and bring all my non-55-year-old tools without fear of Queen Agnes's wrath. The aftermath in Creekside Meadows was profound. Agnes's reign of fear faded, residents started engaging more openly, and the supervised elections brought in a new board of reasonable, competent people genuinely interested in community service rather than control. Despite his initial hesitance, my father was persuaded by neighbors to serve as an informal advisor during the transition, helping the new board and county-appointed receiver clean up Agnes's mess. The receiver, a retired city manager experienced in turnarounds, worked with the new board to revise the CCRs, removing vague or unenforceable clauses, streamlining processes, and ensuring legal compliance. Finances were straightened out with transparent accounting, and the focus shifted from petty rule enforcement to genuine community improvement. Agnes Periwinkle became a ghost in her own neighborhood, stripped of power, publicly disgraced, and forced into retreat. Her navy blue power suits and clipboard were relics of the past. Some neighbors said she eventually put her house up for sale, unable to live in a community she no longer controlled or influenced. Whether she found another place to dominate, I don't know, nor do I care. Her downfall was the result of her arrogance and underestimating those she tried to control. She picked a fight with the wrong family, one armed with knowledge, resources, and relentless determination, not only to win personally but to fix a broken system. Now, my parents live happily in Creekside Meadows, a peaceful, friendly neighborhood as they'd hoped. The lawns remain neat and the mailboxes still match, but there's a lightness in the air that wasn't there before. The saga of Agnes and the HOA upheaval, as some residents jokingly call it, has become a local legend, a cautionary tale about petty power abuse and the importance of vigilance. My father never explicitly banned the HOA by a single decree, but by expertly using the system, guiding us to expose their illicit foundations and overreach, he orchestrated a scenario that forced county intervention to dismantle their corrupt structure, purge the old guard, and ensure they no longer operate outside the law. It was a revenge plot carried out not with a bang, but through the steady, grinding gears of justice and bureaucracy, far more devastating to a paper tiger than any explosion. So, if you're facing your own HOA nightmare, remember our story, do your research, gather evidence, understand the law, and don't hesitate to challenge illegitimate authority. Sometimes the pen, backed by thorough knowledge of county ordinances and a well-crafted legal petition, is mightier than the sword, or in this case, the clipboard. Thanks for listening to my wild story, and don't forget to share your own HOA battles in the comments. It's comforting to know you're not alone in the suburban trenches.